In this case, we meet a student at Cambridge University who was, according to the laws back in 1902, a minor, not yet having reached the age of 21. He was a stylish young man with a rich father. He ordered 11 fancy waistcoats from a tailor for a guinea each. In context, each waistcoat cost more than the average wages for a whole week in England at that time. The waistcoats were not paid for, presumably because the rich father was unamused. The tailor sued on the basis that even though his customer was a minor, the waistcoats were necessaries because they were normal things for a young man at Cambridge to have. The court did not actually doubt that waistcoats were necessary items for your well-dressed young Cambridge man, but they did rather doubt whether it was necessary for the tailor to make him 11 of them. As a result, the court narrowed down the concept of necessaries, stating that minors could only be bound by their contract for necessaries if they did not already have a suitable supply. Lord Justice Fletcher Moulton said the plaintiff has to show first that the goods were suitable to the condition in life of the infant, and secondly, that they were suitable to his actual requirements at the time. Or, in other words, that the infant had not at the time an adequate supply from other sources. There are some problems with this though. In this specific case, it should have been obvious to the tailor that the young man had an adequate supply of waistcoats because he was selling him 11 of them. The court was quite clearly stepping in because there was a sense that the tailor may have been taking advantage of the young man's vanity and immaturity. But what if the young man had bought his waistcoats from 11 different tailors? The 11th tailor would still have been selling him a waistcoat in a situation where the young man had a more than adequate supply. But how would the tailor have known? It's not like he could demand to inspect his client's closet. The best way to read this case from a common law perspective is that the court will intervene to stop a minor from being bound, even for a contract for necessaries, if the court senses that the merchant is taking advantage of the minor.